thank you for the introduction, and thank you to the team at Business World for kindly hosting us and inviting us to be part of this panel. So the theme of this panel is Indian and international ADR landscape. Which side are the GCs leaning on? Now the background to this is that the next decade for India, the interplay between the rule of law and progressive capitalism will be very crucial. This is also important in the background of understanding that how crucial is ADR going to be from the context of ease of doing business. So we are going to be exploring several nuances, surrounding the ADR landscape in India, coupled with what the offerings abroad are. We'll probably also segue into, institutional mediation in India and the advent of the new Mediation Act. So I'll, straight away open the panel and address the elephant in the room. Now, Rajiv, we understand that you have a fair amount of experience in mediation and institutional mediation. With regard to mediation in the Indian context, do you think that mediation is a sufficient module to be able to sort of, navigate through and resolve complex disputes? And the advent of the new Mediation Act, how has that sort of changed the, the mediation landscape in India? What are your thoughts there?
Thank you. Am I audible?
Yes, you can.
Yeah, thank you. So if you see that conflict in any society is inevitable, right? So, but the combat is optional, and litigation is one such kind of combat, which is we should avoid. And mediation is the other way out, right? Mediation is a very simple technique actually which we should adopt as a ADR mechanism instead of the litigation, right? If you, I will go, and this, you are talking of Mediation Act right now that we have passed, but it is, the mediation is not a new concept, at least in India, right? If you will go, somebody has said that even in Mahabharata, Lord Krishna has tried to mediate between the two parts, the Pandavas and Kauravas. And the similar efforts were being done previously in many spiritual, in fact, if you will find out in the events that has been done, right? So in fact, there's one shloka also, Sarvam Sukham, like that, I'm not remembering right now. But that means that mediation actually is going towards the peace, and peace towards the spiritual essence, right? So I am very in favor of the mediation, because I personally feel that this, not only this act, and this is going to be a big boon for us actually, right? Because there are so many cases are fighting, litigation is there in the courts. And if you go by the international arena, in fact, we have already signed the Singapore Treaty, and in Singapore, Turkey, Austria, all their mediations have been doing very well. And I think we should go ahead with.
Thank you. Those were very interesting remarks, and the connotation you drew from the Mahabharata was even interesting. Rashmi, it'll be good to have your thoughts on, we're segueing into, the Arbitration Act now. The 2015-2019 amendments, contemplate for a more stringent timelines in terms of completion of proceedings. We also understand that some of the, the Indian institutions, most of them, in fact, all of them, have more stringent timelines for completion of, pleadings and completion of proceedings. Now, how relevant and important is that from the context of, being the decision maker and the stakeholder, in arbitration proceedings? Is that reassuring from the context of, risk assessment and risk management, that there are stringent timelines in place? How helpful is that? Are these amendments, an enabler for you to consider institutions or, arbitration over the other forums in, litigation perhaps? What are your thoughts there?
So let's just go back to why we started venturing into arbitrations, why it was started. Because there's such an overload of litigations, of cases, that we needed alternate dispute resolution. What is the advantage of that? That we have shorter timelines. We are not waiting for 5 to 10 years for our cases to resolve. If that is the scenario we are looking at, and arbitration is necessarily requiring short timelines. And when we go into arbitration, as a general counsel, I can speak, by the time I have taken the matter, I've already done several rounds of conciliation. I'm completely ready with the matter. The content is absolutely available to the client as well as to the claimant as well as to the respondent. And if you then go into arbitration and then start asking for extra time as compared to the schedule that may be decided and the schedules which are there under the rules of the various organizations under which we go into arbitrations, if we start questioning those timelines and if we do not stick to it, then those 18 months within which we are required to complete those arbitrations go to naught. That entire exercise becomes, redundant, that we weren't able to complete it during that period of time. So if arbitration is the way forward that the company or the individual who's contesting an a contract, breach of contract, then you have to stick to the timelines. And normally people are able to comply with the timelines that are set in the arbitration schedule by the arbitrator, but the extra times are just taken to make things hang, make things delayed, trying to assess if the other party will back off. Sometimes there's some settlement going on, but the bottom line is, if you cannot stick to the timeline that is given, the whole arbitration process becomes redundant, becomes flaked out, is not complying with the bottom line of what is actually required when you are getting into arbitration. So arbitrators have to be very strict about this and impose costs if extra time is being taken. And personally, I have seen that many counsel are taking a lot of time. Arbitrators, in the interest of the claims that are there, tend to give some complications, sometimes may require extra time. But unless you can stick with it, the entire process comes to naught. That's my view.
I mean, it's also interesting in the background that, this is only for domestic arbitrations, and international arbitrations, it's a free world, so there is more time. And this is again in the background that the efficacy of the entire process should not be hampered. In the run-up to meeting those timelines, one shouldn't sort of, hamper the efficacy of the entire adjudication, is what I think is the key takeaway. Now, Sanjukta, we discussed offline. You have some very interesting experience when it comes to institutional mediations from an international context, right? And there are some very interesting nuances that I believe you'll be able to share with us. And when you do throw some light on mediation from an international context and institutional mediation, what lessons can we draw from those in terms of implementing those in the Indian landscape? What are the key takeaways?
Thanks, Juvraj. Good afternoon, everyone. I represent LTI Mindtree, but the views expressed here are personal views.
That's a good caveat.
Yeah. So just for those of you who don't know, LTI Mindtree is a $4.5 billion entity. IT service provides IT services. We operate in over 30 countries around the world. And we are part of, the $25 billion L&T group. We are listed separately, and about little over a year back, we completed a very successful merger of two listed entities, which is L&T Infotech and Mindtree Limited. So we are about 85,000 people. The reason I gave you this background is obviously because of the international angle here, right? So I'm here to talk about JAMS in the US as as an institution to conduct both arbitration and mediation. Personal experience of referring two large disputes to JAMS in New York, and one of the most critical things in any dispute, I think, is the timing of referring it to mediation. Okay, my experience is with mediation, but it's the timing. You will not be able to get the kind of resolution that you want, both from the company's board and maybe the other party is also not interested if you decide to take it to mediation straight away. And here I'm referring to ad hoc mediation and not what is already agreed. If it's agreed, it's different, but you can also refer it, you can also go there for ad hoc mediation. JAMS, I mean, I can tell you with personal experience, is an excellent center for any kind of international disputes, plethora of disputes from employment to commercial and personal disputes. So, and the kind of experts that they have, it's established over 45 years ago with a number of centers in the US. And another disclaimer, I don't represent JAMS here, but so it's not like SAIC you have, you know, or London Center, so it's when you, so timing is important. The other thing which we often overlook, and this is a key takeaway that I want to give, is involvement of your insurer, whether it's an employment dispute or a commercial dispute, because without your insurer's buy-in, you will not be able to, you know, get their support, and they will not be able to, you know, make their part of, you know, the promise in terms of the policy. So involving them, and they'll have a number of questions, you know, and so you need to look at your insurance policies and be prepared to engage with them and push them to accept. I mean, you obviously, all of us know, you know, what their first answer will be, but we need to be able to, you know, we are convinced and therefore this is the best way. So timing, and even though, and in both the instances when we referred, you know, the matter to, took the matter to JAMS, we were in advanced stages of litigation, right? That's why timing is important. But whenever there is that, in terms of a doubt, you know, whether we will be able to succeed, because gung-ho, right, at the beginning we'll say, you know, what we, our position is the best, and therefore, and then you have people in the top management, you know, you need to manage them, and the thing is that this is it, it's black and white, we find a counsel who will agree with, you know, what we believe is the outcome, and so we go in. But then along the way, there is obviously enough, you know, enough to put a bit of a doubt, and therefore you refer it at the right time, and then both the parties have the, are, you know, able to understand that perhaps mediation is the best way, given the kind of complexities, e-discovery process, I'm talking about US, here, and the costs involved, time, cost, distraction, jury trial, you know, having depositions of your senior managers there, all of this can be avoided if you, you know, consider mediation from a institute such as JAMS. So we have referred, coming to the specific disputes, we have referred, you know, multi-million-dollar, 8-figure disputes such as class action, public information, to JAMS, and successfully mediated and, you know, brought the amount to a very, very agreeable sum. So posturing aside from, you know, the other party, you know, you get down thorough preparation, submission of mediation statements, selection of the mediator, obviously, and then exchange of mediation statements, and be prepared. Now, when you're in mediation, be prepared that, you know, you're going to, at the end of it, you will, neither party will be very happy, right? That's the job of the mediator. But we will feel that this is the best outcome on the day, given all of the risks that I already mentioned. And we've had one dispute from class action to the other single, you know, employee dispute, where the demands were also to, you know, build cricket stadiums and Ram Mandirs, and ability for the individual to, you know, manage those. So wide spectrum, but both very successful, concluded successfully, and to utmost satisfaction. Yeah.
I think the key takeaway is that the mediator ensures that either both parties go home happy or unhappy. So that ensures the balance. Now, Mr. Sen, you know, I was hoping to open the panel with you, but we're saving you for the end. This is before Mehak. You know, there is, no, we'll come to her as well. There's a host of experience behind you when it comes to all things arbitration. We've touched upon mediation, you know, in the domestic landscape, and also, you know, internationally, what Sanjukta pointed out. We've also sort of tried to understand some nuances around timelines in the domestic arbitration. The theme of the panel is also intended to discover how India as a venue can be promoted for international arbitrations. Now, it'll be interesting to sort of have your thoughts, on the aspect that if, there is a ad hoc specific statute only contemplating the mechanism for conducting international arbitrations in India, would that have an impact? Would that be an enabler for promoting India as an international hub for arbitrations? Because I believe that's also the underlying theme that we're looking to discover. What are your thoughts there?
Yes, sorry, am I audible? Yeah, that's a very interesting, that's a very important point which you raised. Before I touch upon that, just two things about mediation, which is very interesting. Of course, I come to these mediation conferences with a bit of alarm because I'm way advanced into litigation and arbitration. And one worries about mediation taking over, which it is in many ways, because arbitration has lost its spirit. It's become too complex, as what Fali Nariman himself talked about. Just two quick points, I'm sorry, digressing a little bit.
By all means.
One is that the timing, as was pointed out, I'm recently doing a case where there is a fight with the insurance company, and insurance company not taken on time for the dispute. And what has happened is, there is a settlement which has come for 20 crores. Prior to that, there were legal fights going on, the costs of which are 100 crores. So there was an indemnity clause in the insurance agreement, but the insurer is saying that you did not take me in at the right time. You should have, prior to even starting any strategy on this, I should have been involved. So I think that's a very critical point, and it shows how it makes a difference. Second, mediation is also inbuilt into our systems. I mean, so many GCs tell me, "Khatam karo isko, let's finish it. Why we have to go on for so long? Isko, get some solution, get an interim order." That's normally the case. So I think mediation has a lot of scope. There's tradition of mediation. There are guilds which we had. So I think that's a very important aspect. Now coming to the legislation part. You see, if you look at the UNCITRAL model, on the basis of which the Arbitration Act of 1996 is based, what was the purpose of the UNCITRAL model? If you go into the travaux préparatoires, that is the minutes of the meeting which led to the model law being framed by UNCITRAL, what their concern was that you're looking at having a uniform system of enforcement and a kind of a free-flowing system of arbitration which is there. Now you are going to be having different countries with different cultures and different levels of development, and accordingly they will interfere in awards in different manner. And therefore there should be only, as far as international arbitration is concerned, there should be a model law which should be there in all countries. And that should be divorced from the domestic law. What India did was did a hybrid. It took that UNCITRAL model and has applied that to domestic law also. The result is, and that is something which judges feel, in various conferences when one has been fortunate in hearing them out, they say there are kinds and kinds of awards in domestic arbitration. I mean, there are some awards which you can't, they are what are called lawless awards. I mean, they are absolutely, you can see it on the face of it. Either there has been some corruption, there has been something there, and the judges develop an instinct looking at a brief, what it's all about. And then there is a need, there is a strong desire to interfere. Now that becomes the precedent for even international issues which are coming up. And then you have these, now for example, the recent case, which is that one which is in curative, interfered into. 8,000 crores have gone. There's a lot of criticism. But I can also understand one aspect of that there is something in that 8,000 crores of public money is going somewhere on some kind of a fault which was carried, which happened in the arbitral process. So I think a separate act will do 2 or 3 things. One, it will build up a jurisprudence which is restricted, which is specialized, tuned with the international standards. There will be a bar, already an arbitration bar has come in now, and there will be a bar which will be focused on that. There will be assurance to the foreign investors that yes, the regime which is there under this act, it is going to be beneficial. And the other important point is Singapore, Australia. They have taken separate acts for international arbitration for this very purpose. And finally, we come down to the topic which is there. For GCs and for companies, if India is promoted as a hub, one is the investment which is coming in, but more importantly is the costs. I mean, every time, even for Singapore, I mean, people think that going to London is going to be very is expensive, but even for Singapore it is not cheap. And let me recently I was involved in an international arbitration. Let me set to rest one thing: no substitute for physical presence in the arbitration. I'm not saying that to ensure that I get a fee for international travel, but it's a fact. I was in this arbitration where the matter was going on. It was governed by English law, so I just had more of a supervisory role just to see what was happening. And at the end of the break, say every time they would have a break, my assessment of what the arbitral tribunal was thinking was completely at variance at what the people there at the spot were seeing. Because you can't make out from the video. Until AI and all develop a system by which you can accurately assess how, even by hand gestures, someone is saying by hand gestures or physical gestures, you can determine which way the judge is going to decide. If those kind of levels of development are reached, till then no substitute for physical. So, if you want to have investors in India saying that in India they want to conduct the arbitration with India as the seat, I think a separate arbitration act is a must, and it will go a long way in attracting that kind of investment. It will reduce costs for companies, which will lead to, I think, GCs inclining more towards arbitration.
Very interesting. As a practitioner, I would agree that, at least some aspects to a trial, if I can refer to an arbitration as a trial, cannot be sort of done online. At least, leading evidence or arguing the matter finally, as a matter of fact. So, very interesting. Mehak, let's hear your thoughts on this. You represent GE. Now, it's interesting that, this judgment of Wind Solutions and GE Power, there have been interpretations to suggest that, the court observed that, Indian parties can also select a foreign-seated arbitration. My question to you is on the background that, of course, there are some factual anomalies surrounding, my question, which is, whether the terms of the contract provided for a different mechanism, the interpretation was in the background of the court interpreting the terms of the contract, number one. Number two, is it a no-brainer for general counsels in terms of considerations for choosing a foreign seat for domestic arbitrations? Do you feel that, with the advent of this judgment, the possibility of, domestic, Indian parties selecting a foreign seat will open up, or it's a no-brainer? What are your thoughts there?
So I think I'm first going to give a disclaimer like Sanjukta did. Since it's in GE's favor, I'm very happy about that. But I think I have a tad nationalistic view here. This judgment, or rather the contract that we're talking about, was an anomaly. At least in my experience, two Indian parties very rarely agree to a foreign seat. There's a lot of pushback. And that's because of the enhanced costs involved. And now, since India is becoming such a pro-arbitration hub, at least the government and the Supreme Court with the Arbitration Bar Association coming up, we're promoting it in every way. So I don't think we should be talking about foreign-seated arbitrations. We should be talking about India. And we've got competent institutes now. And they're doing the arbitrations at 1/10 of the cost. So why are we looking at institutes outside India? And I think also in terms of reciprocation, foreign institutes, I don't think they barely appoint Indian arbitrators. It's all foreign arbitrators. So there is a lot of, there isn't geographical diversity in that sense. So why should we not promote our own country there? And one may also think that the scope of judicial intervention reduces if you take up a foreign seat, but eventually you're going to come for enforcement back to India. So I think at best what India needs to currently look at is the enforcement issues. I mean, I think I've been stuck in an enforcement procedure for the last 4 years, and the other parties used every tip and trick in the book to postpone that or procrastinate on that. So I think that's what we really need to work on, but India is the next best thing.
So before you sort of conclude, it'll be good to also have your 2 bits on the mediation landscape. I mean, it'll be interesting to know from you because it'll be another general counsel's perspective. how are you thinking about the new Mediation Act and the landscape? What are the offerings there? Are there any offerings at all?
So again, I think I'd read a quote by Fali Nariman that had said that, the future of arbitration is bright because the future of litigation is not. And I think somewhere what he also said that arbitration is losing its spirit. So maybe the same quote can now be applied to mediation as well. I think, but we still have an issue regarding enforcement. So that is something that we, it needs to be worked on. And I think that's why hybrid models are becoming more and more popular worldwide. So we're looking at ARB-Med-ARB, or we're looking at even litigation-Med litigation now, which I think started in Singapore last year. So I think that really helps. And from an international perspective, or rather from an institutional perspective, whether in India or outside, the only way to promote mediation is to promote mediators, which means creating more mediators. And I don't think institutions at this point are promoting nascent, or what I'd like to call infant mediators. They go in for their training, but if you see all the empanelment conditions, you need to have prior mediation experience. So it's like a chicken and egg situation. How can you not promote the mediator to get his first mediation? So, these are small issues that are still there, and I think these are teething problems. They're going to get better, but we need to look at these.
I just want to add here on the both points which we have talked about. Although I'm in favor of mediation, but mediation has certain loopholes which you are talking about, because it is not that favorable to the complex commercial disputes, right? So for that, you have to have the trained mediators, only then, or maybe then in case of, we have to go to arbitration in that case, where they are already trained, then only we can go further to it, right? And regarding the GE case also, there's a good judgment actually, from one perspective, that it gives the autonomy to the parties to decide, right? And it maybe both parties are decide that although they are Indian companies, but they are having the 90% stake, maybe the parent companies are in a different jurisdiction. Then of course they may decide that maybe in your case they have decided Juvraj, right? But all the case hearings were in Mumbai. Right, the cost was already reduced, but maybe because of the neutrality factor, that judgment is important actually. At least it's giving basically court feels that it's the party has to decide where they have to resolve their disputes. Right.
So am I allowed in terms of time constraint?
By all means. We'll have to keep it very quick though.
Yeah. So I think in terms of complex disputes, I think the hybrid model really works from that perspective. And I think we need to keep an open mind towards mediation from the perspective that we shouldn't be considering that mediation fails. Like ma'am had just said, that there's a right time for it. I mean, there are judges who are actually, who in their judgments are writing that the mediation has failed. Mediation just doesn't fail. There's a right time for it. It could be at the beginning, at the end of even an arbitral award, or in the middle of your litigation.
We've very often sort of, as practitioners, Mr. Sen would agree, we've seen that, at the time of conclusion of evidence, very often parties make that suggestion, why don't we sit down across tables and do this, whether it's, negotiating out of court settlement or mediation. Now, Rashmi, there were some interesting thoughts from Mehak on, trained mediators. Now, we also understand that there has been a requirement and discussion for specialist arbitrators, in the Indian landscape for a very long time. Now, what are your thoughts in terms of, is India as a jurisdiction sort of lacking behind on, trained arbitrators? What is the value that you believe they'll sort of bring in? Are these specialized arbitrators, these specialist arbitrators required only for niche arbitrations, or are they the need of the hour? What sectors, in your belief or your experience, do you feel that they're essentially required? Construction disputes, what is the nature of their engagement?
Sure. So I just want to go back to my first question, which you asked me. I missed answering one little aspect where you said that how does the time schedule work well for the risk assessment of whether you want to go into arbitration or not. And in answer to that, I would say that that time is of the essence, just like in any contract, same for the arbitrations. If we do not have a binding timeline for those arbitrations, it's very difficult for a general counsel to tell its management that this is the right time to go into arbitration and not to go into litigation. Because if it's going to take that long, and we have to remember that our timelines are related to our cash flow, and if that money is not coming back to us either through arbitration or any other means of having laid our claim, it is our risk assessment goes awry. So time schedule for presenting to the management to go into the arbitration is very essential. Coming back to your question about expert arbitrator and why India is lacking behind. I would say globally, arbitrators are not experts at the contract, the issues that are coming before them, more so in India. There are definitely certain industries which require, when there's a claim related to a contract for them, that an expert arbitrator, a specialized arbitrator is required. In connection with that, we are now promoting expert witnesses a lot when we are doing such arbitrations. But so far as specialist arbitrators are concerned, we have mostly retired judges coming into the fray, getting appointed, few counsel who have that kind of expertise. But if we have industries like the industry that I belong to, I've been general counsel for 26 years in the construction industry with MNCs. Construction claims are extremely, they have a lot of nuances, they have a lot of technicality that needs to be understood. The same would go for something like IT, unless the arbitrator understands the industry, just like all of us general counsel know that we have a lot of knowledge of the industry we belong to. And we need the arbitrator to have that knowledge too, unless it's not just the contract we're talking about. And as general counsel, the law is something we train ourselves and understand, and we have outside counsel who will tell us, but we know the industry and we know how to apply our legal knowledge into that industry, into that contract. The same is the requirement for an arbitrator. So the specialist arbitrator is one who understands whether the claim, because I'll give you a small example. Delays in a construction industry can be interpreted in the same manner by the claimant and by the defendant both. There's software nowadays which can give you a different result, pro-claimant, pro-defendant. It would take an expert arbitrator having that kind of knowledge to be able to differentiate between the two. So, and in our in the arbitrations that are there in our country, more and more you will see infrastructure is the biggest arbitration claimant. So in this scenario, unless you have arbitrators who are just not generalist, but when you have these institutions, whether you have an ICA, whether you have Scope, doing a lot of public sector undertaking arbitrations, you have ICC internationally, they have these panels where they have the specialists from which, so it is when, even if we are doing ad hoc arbitrations, the parties need to go and get themselves a specialized arbitrator who knows about that industry. And like I said, there are quite a few. I mean, even if you take something like media, that arbitrators, 1 or 3, whatever, have to have that knowledge. Otherwise, what the result that you're getting is an overview, the in-depth of the claim of what needs to be decided has not been ventured into by the arbitrator. Those are my views.
Interesting. I would second that. Very often we've seen construction disputes, especially from the context of delay analysis, a better part of the effort goes into explaining to the the arbitrators or retired judges, what mechanism has been adopted, all of that. So I think life would have been easier if the specialized arbitrator could sort of understand that. So Yukta, quickly moving to you. Now there has been a whole lot of debate from the context of the Indian landscape on choosing between ad hoc and institutional arbitration. This is a question that is put to us as practitioners very often. When we are sort of structuring an arbitration agreement or curating that. So needless to say that my question is also in the background that both have their own offerings. Can you sort of throw some light on, being a general counsel yourself, that what are your considerations? In which cases do you sort of select an ad hoc over an institution, and vice versa?
I think institutional, mediation or arbitration always, because the rules, the procedure, there's a system in it. You'll have, access to, good mediators or arbitrators. So definitely, institutional. But again, it depends on situations, like in terms of timing, and then you may have to, take that call on ad hoc as well. So that's my view. But in terms of the overall, just as a key takeaway, if I were to, if you indulge me, one, of course, is be patient in any process, especially in a mediation process. Be patient, and especially when you go to an institute, it's very structured, and you will have that mediator with you booked only for that particular day, right? And you will have to, block their time a couple of months in advance sometimes. So you could be there, end up being there for literally 12 to 14 hours. And there will be several times in this process of mediation where, one or the other party feels that, and there'll be people within your own group who will say, let's walk, for whatever it is, let's just walk. So you need a mediator within your own team as well, right? Somebody who will always, be that, voice of reason to the team. So it's important to have the right kind of people who have the ability to be able to take that call on that particular day, or ability to reach someone immediately, whatever time of day, to be able to take that call. And be ready to compromise, never lose sight of what is the alternative if you walk out. So don't be, there'll be those people who will say, let's be a hero. Oh, this is not working out. So you need to, be mindful of. These are my key takeaways if you decide, to follow the, refer any matter to mediation, institutional mediation.
Interesting. I mean, this is perhaps one thing I wouldn't agree on. I still feel that, ad hoc arbitrations, it's like in that fight between David and Goliath. When you opt for an institutional arbitration, you're fighting without all your powers. So it's very often, but it's again very nuanced. Mr. Sen, now, I have all the interesting different propositions for you. I mean, I tend to move outside the domain of the current affairs and look for interesting sort of responses from you. Now, in this case of HSBC API Holdings, the Supreme Court made an observation that, whilst sort of analyzing the aspect of arbitral bias, courts should sort of look at international standards. The court also went into sort of understanding and interpreting what the construct of public policy is, from the context of minimum interference. Now, my question to you is twofold. What are these international standards? How distinct are they from, domestic standards, while sort of just interpreting or analyzing what from the context of arbitral bias? Number one. Number two is, how should courts sort of construct public policy also in the background that ultimately their job is minimum interference with the award? That's the intent of the statute, as I understand it. What are your thoughts there?
Yeah, so as far as international standards is concerned, I think one thing which has been very progressive has been the 2015 amendment, where the IBA guidelines were incorporated into the Indian statute. And I think that was a very, very welcome move. I was just trying to check that up, but I think earlier, UK said that the IBA guidelines will be of persuasive value, but there's been a recent amendment by which they have incorporated the guidelines into the Act. Now, India therefore took a lead there. So I think that that's something which, in international forums also I put out, that, to say that India is always lagging behind is a misnomer. But in those IBA guidelines, for example, when we take the 7th and the 5th schedule and compare with the 2014, now the 2024 have come out. But if you say, now if an arbitrator, one of the guidelines is disclose if you are a close friend of the counsel. The arbitrator has to disclose that. Disclose if you have an enmity with the counsel. That's not part of the schedule. Now that's the crux of the whole thing. So you see, if you want to incorporate the schedule, then it should be as amendments take place, those will be taken in full scale. So it's like the UNCITRAL model, how we put it. We've done a kind of a mixed job. So that is one part which we must be very careful about. Second part, as far as interference is concerned, increasingly there's a trend where on grounds of fraud, interference is becoming more prominent. The recent Nigeria case in UK is a case where Nigeria had hardly put up a fight. I mean, you'll see that very often with public sector corporations, badly paid lawyers coming and fighting and making a mess of the case and losing it. Nigeria had to pay $11 billion, which was a substantial part of its GDP, as an arbitral award. That was interfered with after, I'm happy to say, 7 years of litigation in UK courts. People say that UK courts are fast. No. Here it took 7 years of litigation for Justice Knowles, a very well-known commercial mind there, to interfere and said that there was fraud in the arbitral process, there was delay. The counsel did not do the things, questions which he was supposed to ask the government counsel, and therefore it led to an award which was by arbitral procedural for fraud. So public policy, while yes, there is a ground where you have to reduce it, but Knowles has raised points, and he said where public sector is involved or public monies are involved in an arbitration, should there be more interference or not? Should there be more disclosure in terms of confidentiality going away? How much autonomy of parties are there? So these are interesting issues. Time is up, but these are interesting issues. The jury on the extent to which you should interfere, and there should always be minimum interference, is today asked for a bit of discussion still. I mean, it's opened up, new questions have come up, and it's not so clear and bright as before.
Interesting. I don't think we have enough time to open it up for the floor unless the organizers have something else in their mind. But nevertheless, before we close the panel, any closing remarks that any of you have? I think, Rajiv, you had some closing remarks. If you could quickly give us a brief outline of...
I can just summarize in a short poem if you wish to.
Please, by all means.
So we are talking of ADR and the GCs and online AI and right. So I'm just summarizing all these things in a short poem. In courts, overflowing cases stacked high, justice delayed, a disheartened sigh. ADR emerges, a brand new road for swifter solutions, casting out doubt. As India's embrace a framework so strong, arbitration, mediation, where rights meets wrong, online disputes, a digital ease, resolving conflicts with virtual breeze, confidentiality, a cloak we create, sensitive matters, a private debate, across the globe, a mirror designed, TTs like thread, a unifying line. For GCs like us, a welcome embrace, saving time, money, a winning pace. So let ADR flourish, a future so bright, where conflicts find solace in fair light. India's potential, a beacon to see, in harmonious grip for all to agree.
Very interesting. I think this is the most interesting panel. We started with poetry. No, we started with prose and we ended with poetry. This has to be the most interesting one. Thank you. Thank you, ladies and gentlemen, for being with us.